Yes. Good afternoon, ladies and gentlemen. I am Richard Wee from the law firm of Richard Wee Chambers. Actually, this is a series of webinars organized by my law firm. It's a RWC webinar, the Impact series. You can find us on Facebook under Richard Wee Chambers, Instagram, and on LinkedIn. You can find us there. We're also on Twitter. So all our updates on our webinars are there. Today is, I think, if I'm not mistaken, the 9th or 10th webinar. We've lost count of how many webinars we have organized. So Richard Wee Chambers, about 10 days ago, Rachel, right? About 10 days ago, organized a webinar with Brickfields Asia College on the impact of employment, human resource, and industrial relations. That talk was, we had 400 over people registered, and at the peak of the event, more than 280 people logged in to watch the event. That webinar has been recorded and is uploaded on my law firm's YouTube. You can look at YouTube, Richard Wee Chambers. You can find the first recording there. And that video has been viewed hundreds and hundreds of times. So there is a great interest in this area. So flowing from there, Brickfields Asia College informed my law firm, Richard Wee Chambers, that there is a great interest to do this again, and we decided to hold it again. And we re-invited Miss Rachel from MECA, an employment consultancy agency, to come back. Hi, Rachel.
Hi.
Yeah.
Hi. Thank you.
I will invite you later to introduce yourself. And today we have a special guest, Bobby Gay. Bobby is a human resource consultant. He's been doing human resource areas for more than 30, 40 years. He's effectively an expert in this area. In Penang, he's based in Penang. He's agreed to come on. Thank you very much, Bobby, for spending some time with us. And interesting information for everybody who's logged on, especially those who may have logged on for the second time. Actually, the first session we had 10 days ago, we had a speaker by the name of Miss Pamela Gay. And her surname is exactly the same surname with Mr. Bobby Gay. That's because Mr. Bobby is the father. So Uncle Bobby very kindly agreed to come on board to share his experiences and knowledge and information about human resource, right? This is how we'll do it. First, we will invite the two speakers to introduce themselves. And then I will set the tone by giving 4 scenarios of discussion. We will be discussing pertaining to the issues of salaries, the deferment of salary, cut salary, stop salary, that issue. We will discuss about Employment Act also. Then there's an element of a trade union that we may also have to take into account. Second issue, we'll talk about issues of forced leave, unpaid leave, and whatever connected to leaves. The third issue is the potential issues of retrenchment. What can the company do? And MECA will also offer ideas on, hopefully we won't go there, but if we have to go there, how do we do in retrenchment, and what are the rights of the employees during retrenchment? And last but not least, we will be discussing about the government subsidy, on how the government subsidy operation works for purposes of paying wages. Mr. Bobby, correct? All these issues, yeah. And that will take us nicely to about 5 o'clock. And Brickfields have kindly informed us that they are willing to extend the time because the topic is a very, how should I say, a pressing topic, which everyone is very keen to learn. So without further ado, let me first invite the two speakers to introduce themselves. Bobby, can I invite you maybe 1 minute to share with us your name and what are you working as and your experience? All yours, Bobby.
Okay, thank you, Richard. My name is Bobby Gay. I've been in HR all my life. That is probably about 40 years now. Started in 1977. I've always been with multinational companies, mostly Americans, Europeans. As I told Richard, doesn't mean that a person with 40 years experience knows everything. All right, we still learn. And I'm glad that you have invited me to participate and give my thoughts on this matter. These are my personal views, and of course, Rachel will be able to share her view in terms of what the legal aspects of it. Thank you.
Thanks, Bobby. Welcome aboard all the way from Penang. Yeah, and I really miss going to Penang. In fact, in this moment in time, I even miss going to Rawang. I miss going to Klang. I even miss going to PJSS2. Anyway, just wish we can just get out, you know. Yeah. Rachel, poor girl imprisoned in your condo. You're stuck there, you know. Share with us a little bit about yourself, and maybe more importantly, tell us your experience and your work with MECA. All yours, Rachel.
Thank you, Richard. Nice to meet you, Bobby.
Yep.
It was very nice to speak to your daughter, and I look forward to speaking to you later as well. Right. Hello, everyone. I'm Rachel. I am a legal counsel with MECA. We are actually a boutique firm that does consultancy on the employment-related matters, IR. We started 24 years ago, and I think we have currently 3 branches, one in PJ, one in MECA South, which is in Johor Bahru, and one in Penang at Jalan Kapal Singh. So with this 3, we have been having a group. Our group of clientele or members, we call them, is about 500. They are made out of MNCs, SMEs. Recently also we have a couple of startups as well who have joined the bandwagon in our consultancy. My job is usually giving my client bespoke idea on how to handle their day-to-day employment matters. Currently, as we all know with the MCO, my job revolves around giving them more ideas of handling employees during the MCO and during the pandemic. So yeah, yes, and I know Richard say he called me this little girl, but I'm not a little girl. I'm actually about 34 years old.
I was trying to make you feel younger. Please forgive me.
Okay, I will never trade my age for a younger version of me because this way much better than the younger one.
Good. Keep it up. Yeah, that's the way. Thank you very much for that, Rachel.
So,
yeah, go on.
back to you.
Okay, thank you. All right, thank you very much, Rachel. So, ladies and gentlemen, below the screen, you will see a Q&A icon. You can click on it. Do put in your questions. We have a lot of people. We have already got 150 people. Thank you so much for logging in. And we expect, just like the last session, there will be an avalanche of questions. The panelists will try to answer as many as they can. We may group them together depending on the issues and address them. Of course, at the end of the session, we will share with you. You can contact Mr. Bobby or Ms. Rachel privately at their respective emails or whatever. So without further ado, let's start. So there you go. You heard Bobby's experience and Rachel's experience. As for me, being a lawyer, I've been in practice for 21 years. My law firm do predominantly corporate litigation, corporate work and civil litigation. And one of the areas that we are servicing is employment. So we do offer a general advice on employment. For today, I repeat for those who are latecomers who just logged in, the 4 areas that we are going to deal with is the issue of the salary issues, which is a very big issue. How do we deal with the salary and whatnot? Issues of unpaid leave, issues of retrenchment, principles where we can apply to carry out retrenchment, and the current government subsidy for salary. So, Bobby, my first question is, well, not really question, an observation. In your years of practice as human resource consultant and professional, what is your observation so far pertaining to the steps taken and the principles used by many human resource department in deciding whether salary can or cannot be adjusted, delayed, unpaid, cancelled? You know, there have been many scenarios. So maybe you can give a general observations on the principles which was used by the human resource department in coming up to what they have to do in their companies. All yours, Bobby.
Okay. Basically, as far as salary is concerned, I mean, it's a contractual thing, right? So which means that you pay a person 2,000 ringgit, regardless of whether you make money or you don't make money, you still got to pay the person the amount that you have contracted. Now, in this current scenario, a lot of companies are facing financial difficulties, cash flow problems, and so on. Now, the question now is, can they change salaries? Can they reduce salaries, right? And I mean, even on that, there are companies who have asked, can we even reduce benefits? There's a company that gives 15% ETF, right, which is over and above the law. And then now they have come and said, we would like to reduce it. Now, as we all know, reducing terms and conditions, fundamental terms and conditions would lead to cases in industrial court, right? So we've got to be very careful in terms of salary, because that's what we contract with employees. I mean, again, as you have started to say, there are probably three groups of people we need to address. One is those covered under the Employment Act, right? Those earning 2,000 and below. Those who are out of the scope of the Employment Act, and how can we treat these people? And the third category of people are people who are covered under collective agreements who are unionized. So the treatment of all these three categories would be different in terms of salaries and benefits.
I like how you raise it. So just to summarize before I invite Rachel to offer some views, ladies and gentlemen, Bobby has mentioned in short the three categories of work that we're going to look at. People under Employment Act, number one. Second category, the workers earning below 2,000 ringgit. And the third one, people who are involved in the collective agreement, or some people we call it the trade unions. So we'll be kind of looking at that later in more detail. So Rachel, in your experience so far, the last 1 month since the MCO has stepped in, what have you observed pertaining to when advising your clients pertaining to salaries, deferment, cancellation, stopping, etc.? Maybe you can give some observation.
Based on my observation from the last couple of weeks, I find that companies who are struggling tend to, number one, have the urgency to commit to plowing through the idea of unpaid leave or even pay cuts due to the situation they are in now. Because failing which, if they can't get them the pay cut to be executed, they might not be able to sustain the company as a whole. So I observed that there is a lot of pressure, both companies and the employee, to consent to this unpaid leave or pay cut. Now, the thing is about pay cut or unpaid leave, because contract itself is consensus ad idem, is the meeting of the mind. You enter into a contract with your company for a certain amount of money for the work to be done, right? And for the terms and conditions to be set to be unilaterally changed, usually not permissible, and you're not supposed to do that. If you commit to doing so, it could amount to constructive dismissal. The employee could walk away and file a case in court, right, under Section 20. So right now, we will tell our client to endeavor to get consent. Now, the problem with consent is you have to think of two things that might come into this idea of consent. Is there any vitiating factors? For example, duress. Is there undue influence? How are you telling your employees to consent to this? Are you putting them in a room? Are you forcing them to sign without their permission? What are you doing exactly to get those consent? Now, if there is any sort of duress or any sort of undue influence, it also can be raised later in court that you have used those factors to force them to agree to something that they do not want to agree to begin with. So these are things that you should also be careful of when you're trying to get consent from your employees. Yeah. So that's in telling our clients to be extra careful to do.
Yeah. So I like how you approached it, Rachel, where you first reminded all the employers that, jaga-jaga, you buat macam ni, suddenly the workers can activate Section 20 of the Employment Act, the Act, the Industrial Relations Act, and then sue the company for constructive dismissal. So companies has to be more cautious, in doing that. But on the other side of the coin, I like how you approach the issue where we should try to negotiate. On that point, Rachel and Bobby, if I can share my experience, some of the work I do involve a very peculiar area called sports, and I've been asked to advise on sporting salaries on certain professional sports, and because we couldn't really find a way out, and the contract had no force majeure or frustration. Frustration is not there, but force majeure clauses. we decided that parties should try to settle the matter, and we asked for a concord agreement, a joint meeting to come and renegotiate the salaries, very much in the spirit of what you say, Rachel. You know, and can I add this thing about football, for example, sports, for example? People say that we must have force majeure clause. You cannot have force majeure clause in sports. If you are advising a club like Manchester United, and you activate a force majeure, you lose the player for free. You cannot then sell the player. So it doesn't work that way all the time. So back to this, Bobby, you've set the tone pertaining to the three group of workers. Generally, how would you deal with sorting out the salaries of these people? I mean, if you are the human resource officer and of any company, or you are asked to give advice as a human resource professional, they'll ask you, hey, Bobby, bro, how do I cancel the salary? What are the principles that you will apply in deciding for these three areas? The Employment Act, people below 2K, and people under the collective agreement. All yours, Bobby.
Okay, basically, I think a lot of companies are trying to do this right now. Most of the MNCs in Penang are talking about it. I've seen some companies already initiating it, where they've come up with a percentage cut by levels, from top management to middle management to the lower level. And I just want to add on to what Rachel said. Like, if you force people, then it becomes a constructive dismissal kind of thing. But all companies have this standard formats that say, at this level I take a 50% pay cut, at this level I take a 20% pay cut, and for next 3 months or whatever, right? Now, this could also be interpreted as, you're forcing me because I got no say. I just signed at the bottom that says I agree to this, that's all, right? So although yes, everything is negotiable, but bear in mind that if you don't have 100% of people agreeing to it, how are you going to handle it? Let's say you've got 100 workers, and out of that you have got 80 people who agree, 20 people who don't agree. So what are you going to do? Are you going to implement for the 80 people, and then the other 20 just leave them alone, or find ways to get rid of them, so to speak? Right? So at the end of the day, it's unprecedented for HR people today. I would hate to face a situation like this if I'm still working, because it's always unpleasant to do this, because different people have different needs, and you will find that not everybody loves the company that much and say, yeah, I will take a 50% pay cut. Right? So it is a difficult thing to do. There is no formula. A lot of companies are saying, look, I guess what is important at this juncture is for companies to be transparent. A lot of Chinaman company that I know are not transparent, meaning when they make tons of money, they keep quiet, and when they lose money, then they start looking at this. Now, multinationals tend to be more transparent in the sense that on a quarterly basis, on a half-yearly basis, or yearly basis, they do whole sessions and tell employees that they are doing well, they're not doing well, the stock prices gone up, they have gone down, and so on. So I guess at this juncture, companies, communication is key in this, in the sense that employees of all levels must be made to understand that the company is facing this situation, and hence these measures are necessary to keep the company afloat. Of course, short of that, then we will go to topic 3 that we wanted to talk about, is that we will lay off people. Right? If a company cannot survive, then the ultimate choice is to lay off as many people as you can. Right? So going back to salary, there is no methodology. I've seen companies who have come up with saying that 50%, 20%, 10%, and they give a timeline in terms of next 3 months. But then, I don't really know what is the best method to do.
Yeah,
it depends on the company. What is their cash flow right now, and at the end of the day, do what is, as I spoke to you recently, and I said, what is the right thing to do and what is the wise thing to do. The right thing to do legally you have the right to do it, right? But is it a wise thing to do at this point of time?
Yeah, I agree with you. We live in this is the most popular phrase now. We live in unprecedented times, but it's truly an unprecedented times. I know it's a very heavily used word, could be overused, but unfortunately, I can't find any other word to describe what we're going through. Yeah, it is truly an unprecedented times. But I like how you put it. Basically, I know for human resource practitioners like you, it is a challenge. There's no one right answer and no one answer which fits all, like what you said earlier. But I suppose there are some ways to find it. Eventually, we'll find some sort of solution. But don't you agree with me, Bobby, that we will not be able to find an ideal solution? There won't be one where everything is nice. There will be somebody who will be upset.
Definitely, that you never have a situation where everybody raise their hands and say, yeah, we understand and we will take a pay cut. That will never happen, right? Not in any organization, right? Not even at the highest level, unless you are the owner of the company. That is different, right? But
True.
you know, in one of the companies I'm consulting for right now, they've asked me this question: what if we don't agree? What can the company do to us? The answer is the company cannot do anything to you. Of course, the company can fire you and will find ways to get rid of you, right? But as far as salary is concerned, the company cannot do anything to you.
Yeah. Well said. I think we are all in a dilemma, but we're trying to find a way. You know, Rachel, I know your consultancy agency, your company has been very active, you know, offering comments and ideas. So far, how is MECA's approach, the principles that you take into account when you approach the issue of potential salary deferment, salary stop, cancellation, etc., etc.? I mean, how have you dealt with the situation so far, Rachel?
Well, there's no one company has the same problem because everybody have a different industry, different background, different employees. But we always tell our client one thing for sure. Like you said, Rick, it's an unprecedented time. But even in an unprecedented time, we have to apply rationality and most of all, empathy. We cannot just use rational, but we have to put empathy. Depending on what sort of, what type of employees you have. Do you have 80% of them are B40? Or do you have middle management mostly? You have all professionals in your company. How will you approach an announcement of a pay cut? It really depending on what sort of environment and demographic you have in the company. So each advice we provide is bespoke to individual company because we first have to understand what kind of people you have there, what sort of engagement level you have with the employee to begin with. Just to share with you, 2 days ago on a Saturday, I received a call from a client who said that he has decided to inform the employee that they all are going on unpaid leave. He's unable to pay them and wanted them to go on unpaid leave. So he did not get any consent. He just announced it. Apparently someone told him that he can do that, and when the MCO is lifted, he could get a signature thereafter. Lo and behold, he received a call from JTK, the Jabatan Tenaga Kerja, Labour Department, saying that someone has filed a complaint against him for forcing unpaid leave. Now, he believes about 30 of his employees who is made out of laborers, drivers, who are now unhappy with his decision. His worry is, what if I get, once we come back and I still need the employees, but they start to sabotage me? How do I break the animosity of things? How do I mend my relationship with the employee? So out of the blue, I did tell him that, look, you have to understand that these people, the only thing they worry about is food on their table. They are already at the bottom of the hierarchy when it comes to food chain. And you are the one thing they worry most, which is to put food on their table. Telling them that they're not being paid at all. Yes, there is no work, but they're not going to understand why you can't even offer them some area of comfort, like a partial pay or an advance. They don't understand. So I just gave an idea. It's just out of the blue. I told him, look, the least you could do is, can you offer them groceries, necessities? Try to talk to them and say, look, I cannot pay you because I really don't have the money because there's no work to be done. But I can subsidize your monthly groceries, your allowed food for your family until we can get back. And then I asked my client, can you do this? He said, that's a good idea. I'm going to give it a try. I don't know what's the outcome yet, but there is no one method is the same. So he's going to give it a try. I said, two things will happen. Employees will come forward and take those, whatever you're offering them, a small gesture, will probably be the one who's going to agree and sign off the unpaid leave. So long that you are trying to engage your employee in the right way, there's no one right way lah. In your own way, right? They are more willing to cooperate with you than against you. Now is not the time to cari pasal with your employee, honestly speaking. You try to get them to understand your perspective, right? So I gave him an idea which is completely not a legal perspective. I just said, why don't you give it and try and see what happens? He said, yes, I'm going to give it a try. If there's any positive outcome, I'll let you know, Rick.
Yeah, please do. Please do, can share. Yeah, share, you know.
It doesn't have to be cash. Sometimes you just need to understand where your employee is coming from. Where are their worries? Yes.
Yeah, sorry. I thought you stopped talking, yeah.
Because it's lagging.
Yeah, no worries. So in fact, I apologize for that to the participants. In fact, I recall the last conversation when Pam was speaking. Pam gave the idea that company may defer the salaries, and then later with the undertaking that later when the company is back, they get back the money. You know, there is some way. There's a mechanism like we can work around it. But of course, like what you said, Rachel, and in fact, Bobby said the same thing. There is an element of consent. We need the consent lah. But can I share with the two of you, back to the sports thing, for FIFA, when they dealt with football, they gave a mechanism that first, the sports clubs, they must deal the employment internally, look at the contract. If they can't, look at the national law. Every country got their own law to see how to deal with the employment of the sports contract. Thirdly, it cannot then go to a negotiation, joint negotiation, which they are now at. And fourthly, if really cannot negotiate, people cannot agree, then the clubs can unilaterally do what they want, but they must be prepared for the consequences. I think that seems to be the quite an approach to do now also, you know, if you ask me. You know, I think some companies, they got no choice, they got to do what they have to do to survive, and then they have to be prepared for the consequences. You know, so I think.
Which I just want to add, I mean, these are my thoughts. I just want to add to what Rachel said. Now, if you look at the Act, it says that we must pay people in legal tender. Giving provision doesn't amount to legal tender, which means that you supply food. I mean, that's a good thing to do, right? But the law does. I mean, the current law, right, doesn't allow us to do that. Doesn't allow employers to substitute salary with groceries. Number one, right? That's my view. Right? Secondly, on deferment, also is a very tricky thing because the law says you must pay salary 7 days after the wage period. The law doesn't give us any leeway of deferment at all.
Yep.
So again, you know, what is right to do and what we should do. Again, these are difficult times, but then bear in mind that going to industrial court, the court presidents will have to fall back on precedents, and there is no such precedent for them to fall back on, right, so far.
Agreed. I agree with you. That's why, in fact, I think for people like the three of us, whenever we give advice, it's a challenging time to give advice because some of the advice we give may or may not have a good consequence. So it's quite dangerous. Oh, so okay, let's move. It's only 4:30, ladies and gentlemen. We got about 190 people logged on. We got 17 questions already. We will come to the questions soon. Some very good questions here. Some about subsidy, some about the retrenchment after receiving subsidy, etc., etc. So keep on coming. The question we'll try to answer all. So flowing from that, very short topic of discussion. In fact, Rachel, I think you mentioned it a little bit. It's about the unpaid leave. So maybe Bobby, you want to give any short comment about what are the principles pertaining to a unilateral unpaid leave? Any comments?
Yeah, basically, I mean, I think if you look back on Industrial Court Awards, I think one of the Industrial Court presidents, probably in the 1980s or early 90s, said, Justice Harun said that annual leave or leave, is for the employee to use at his discretion, and hence employers cannot force an employee to either take annual leave, to take unpaid leave, and so on. So, I mean, the law says the employer shall grant and the employee shall take, which means that I will apply for leave and then you approve and then I take it. That's how I interpret the law. Now, the same goes whether it's unpaid leave or whether it's annual leave, right? So we cannot force employees to decide or at this time to say, no, I want you to take 3 months unpaid leave, or I want you to take your annual leave. So that is the dilemma that most employers have today, in terms of like, okay, I mean, there was one question that was posed to me earlier that says we cannot afford to pay salaries, so can we ask the employees to take unpaid leave? I think when we get to the part on government subsidy, yes, I think there is that portion that allows employers to get their employees to take 3 to 6 months unpaid leave, and then they can then jump onto a subsidy given by the government, which is basically a 600 ringgit, that is called the Employment Retention Program. Right? There are 3 programs right now under SOCSO. One is the employment insurance, which is where you lose your job. The other one is the Employment Retention Program, which the government is trying to get employers not to fire people. And then in this particular instance, they allow the employer to get the employee to take 3 to 6 months unpaid leave. But this only applies to people who earn below 4,000 and below. Okay, right? And then, of course, the other one is the wage subsidy program.
Well, we will be discussing about that in detail, but I like how you started, because it's all connected. At the end of the day, while we are compartmentalizing our discussion, but we all know they're all connected. A, B, C, D, E, all connected. Yeah. So, Rachel, would you like to give a comment? Because you started off very well. You told us about that classic case of a company unilaterally enforcing no pay leave. What are your views and your observation pertaining to the principles on unpaid leave? Any laws which the 191 people can take into account? All yours, Rachel.
Unpaid leave in general, like what Bobby said, is actually the benefit or the rights of the employee. But it is for the employer to approve the leave. That means you can have leave, but to go on leave it's the right of the employer. Now, this is the benefit that is accrued, and it can be encashed, especially annual leave, for example. It can be encashed. So such is an entitlement that belongs to the employee, which is part of the contract, which is part of terms and conditions of your contract, right? So in order for you to get them to use them, you need their consent to remove those. So naturally, you need them to finally say, yes, boss, I will go on leave. But there are situations because of the MCO. Some of my clients who are essential services have employees who refuse to work. What they did instead is they tell the boss, I'm going to apply for leave. This is my application for unpaid leave. I'm not coming to work. So you have a situation in a really taking leave because they don't want to be working during MCO, even though they are part of essential services. So we have a few scenarios that we are working on. Like I said, my clients are plenty, so different scenario applies for different industry. For those who have license to continue business, we'll have people who don't want to work. Then we have those who cannot continue business and want them to go on unpaid leave. Employee refuses to go on unpaid leave. So there are a few scenarios in that. But legally, like Bobby said, you cannot just unilaterally force the unpaid leave.
Rachel? Rachel, sorry.
Or remove any benefits.
Rachel, sorry, can you repeat?
There are methods that we encourage our clients to apply or members to apply, such as a payoff, a trade-off. Let's say, am I lagging?
Yes, you are quite badly lagging, Rachel. You may need to repeat what you said the last 1 minute because you sounded in and out, unfortunately. Can I trouble you, if you can recollect what you said, the last 1 minute or so? We kind of lost you at the part about you giving examples. All yours. Can you repeat, please?
I'm just saying that in this environment of COVID-19, there are many industries who are facing different sort of issues pertaining to unpaid. We have essential services who have employees who refuse to come to work, thereby themselves applying for leave not to come to work. And there are also employees who cannot work, but the employee refused to take unpaid leave. So there are also different scenarios that we are working off with our clients. Having said, we still need our employer to realize that in this situation, you have to apply your discretion. You can't just say that one shoe size fits all, especially in terms of asking them to take unpaid leave or even removing benefits like what Bobby says. You cannot just remove it unilaterally. But there are methods that we are also telling our client to apply. For example, how about a trade-off? Like, let's say if you want to remove currently a yearly incentive, for example, all right? Normally you will have an incentive or an annual leave encashment. Instead of taking it away or forcing them to relinquish those benefits, how about a trade-off? Maybe pay them a small lump sum to remove those benefits for the company. So things like that is up to the company to consider. There are creative ways that HR practitioners can apply. We are in a space where we can be as creative as we want. HR practitioners currently are in the front seat of the company management. You are steering the entire thing for the first time in history, crisis control. Nobody in history will have your kind of resume for years to come. All right? So as creative as you can for your company, but of course, don't do it within the ambit of the law.
Yeah, I like how you said it, Rachel. And you know, because there's a balance to raise. Bobby has correctly and accurately pointed out that the law before us may not expressly permit payment in kind, deferment. All these are not expressly permitted in the Act. And the way the Employment Act works suggests that if it is not expressly permitted, then chances are it's not permitted. That seems to be the way Employment Act works. But even then, it's subject to legal interpretation. I think as a solicitor and a barrister in court, we will try to interpret it to say, if it's not included, then the company may do. The danger of having that interpretation, it opens a massive floodgate. The company can do whatever they want to do, that is as good as killing the Employment Act. So we have to be balanced it out. But as we said at the very beginning of this chat, and I can't help but repeat and impress upon it, we live in uncharted territories. The ship that we are sailing on are going on to the 7 darkness, 7 black seas, 7 black ocean, never sailed before. So we have to be a little bit creative. Let's see how it goes. So good examples. Now, moving on from there, and this is one area I personally don't really like to talk about, Bobby and Rachel. It's about retrenchment. You know, as much as we lawyers, we do this kind of work. And I must confess, Rachel and Bobby, Rachel will know, I am not some super duper expert law in employment. You know, Richard Wee is not. We do general employment matters, always have employment cases. But I must say, my entire career, I've only done retrenchment less than 5 times for my clients. And in all 5 times is because, not because of this, you know, Bobby, it was because company A was merging with company B, and the merger had to let some workers go because of redundancy, you know. So, Rachel, let's start with you first. If your client comes to you and says, and let's make it quick because I want to go towards the subsidy issue, it's already 4:40. Let's try to wrap this up by 4:45 and we can go towards subsidy. When it comes to retrenchment, Rachel, if a client of you come and say, hey, Rachel, syarikat saya teruk lah, my company in trouble lah, I need to retrench. What are the kind of principles which you will use in order to guide that client in order to do that? All yours, Rachel.
If a client comes up to me to say they want to retrench employee, which just happened 5 times last week,
Okay.
I realized that the reason that they are giving currently is generally because of business loss, because of MCO. But there were incidents where my client are actually making a lot of money and they still want to retrench because restructuring of businesses cause redundancy. Now, redundancy is where there's excess of manpower, and retrenchment is the exercise to remove those redundancy. Now, retrenchment, you can say whatever you want, but MCO is not the reason for retrenchment. I've been having questions coming from my client. Rachel, can I retrench during MCO? Can I retrench because of MCO? Just FYI, there's no such thing in the law say you retrench because of MCO.
Yeah, there's no such thing, yeah. No such thing. In fact, I dare say, not allowed. I dare say, not allowed, yeah.
So you cannot use MCO as a reason of retrenchment. If you say you want to retrench, then you better be ready with documentation, evidence to say that you have business loss. Then we have a chance. Now, retrenchment is a company's prerogative. Yes, you can retrench, but that doesn't mean you can just do it at will without just cause and excuse. You still have to provide documentation. You cannot say, oh, because it's MCO, that's why I need to retrench. Your case is definitely a weak case in court. You still must provide and show that we are having a business loss of how much, and because of that, we have to restructure, and therefore this is the outcome. We have to let X number of people to go, right? And retrenchment principles are guided by the Industrial Code of Harmony. If you have no idea who to let go, right, I would suggest you go through the LIFO, last in first, easiest, okay? But if you think that you would like to have a different sort of structure and you already have more or less an idea who you're letting go, most probably the one who is poorly performed, then I would suggest that you have something called a performance matrix to evaluate each and every employee before you let them go. So sometimes we actually create those sort of a mechanism for our client where we tell them to sit down as a management team to decide who to keep in the as an employee based on the survey, based on their performance review of that particular employee. And with that becomes a part of the documentation. In the event the employee chooses to sue, we have something to say, look, we decided it based on performance. And it can be accepted in court as well.
I see that, Rachel, a couple of times, the way you prepare your clients is that on the worst case scenario, if the company gets sued, then you are trying to lay some sort of evidence to show good faith, isn't it? You're trying to show that the company is doing it in good faith, right? Yeah.
Because retrenchment is still termination of employment. And in industrial court, termination by the employer, the burden of proof belongs to the company, is on the company. So the first person to discharge the burden is the company. So whether you like it or not, you do more work. Unlike the civil court, where the plaintiff, the one who brings the case, have to prove the case. In industrial court, it's the reverse. The one that been brought into court, which is a company, has to be the one proving the case.
Yeah, I know. Every time I go to employment, the industrial court at now in Jalan Ampang there, I'm like, wow. Yeah.
It's always the reverse, right? If you're represented, you realize that the burden is on me.
Yeah.
I wasn't the one for the case, but I have to be the one proving. But the problem is the one who terminate. So the court wants you to justify what is the basis of termination.
Yeah, but that's the law. It makes sense. So we just need to follow. As a lawyer, you tell me the law, I'll do it and I'll get it done. Yeah.
Correct. So because of that.
Yeah, go on.
Yeah, sorry. Because of that, we have to be more prepared than usual for the employers. So you can't just say like, oh, I'm feeling very blue today. I got not enough money in my pocket, so I'm going to retrench 10 people for the sake of retrenching. Okay. It doesn't.
Yeah. So Bobby, well said. By the way, Richard, I like because your comments are very practical, and I like the balance between you and Bobby is very obvious. Bobby is always following, complying with the law very strictly, and Rachel, on the other hand, complying but trying to be creative. Yeah, Bobby, what are your comments? I mean, I'm sure you have extensive experience doing this. It's the most difficult thing in the human resource work to do retrenchment. I remember the few times I didn't like it, but I had no choice. You know, it was my job. I can understand now how George Clooney felt in Up in the Air. You know. Yeah. So, Bobby, any comments about general principles on retrenchment, adjustment of company, blah blah blah? All yours, Bobby.
Okay, on retrenchment, as Rachel says, we use the last in first out principle. However, although it is prescribed, there are, we generally, whether you follow or not, the courts will not fault you, and if you have other reasons of getting rid of certain people based on performance and so on. So although is a code of conduct for industrial harmony is there are a lot of things that generally we do have to follow, meaning no hiring of people, curbing overtime and so on. Those are principles that we use during normal times. At this point of time, I guess the only reasons a company can give is like, I have a cash flow problem, I can't pay salaries, and hence I got to get rid of people, right? Now, of course, in this circumstance where because you have a cash flow problem and you got to get rid of people, then you have no choice but to use the last in first out principle, right? Of course, end of the day, I think one of the things that companies need to look at is how long can the companies last? Are you looking at short term, mid term, or long term? Because sometimes you get rid of people now because you solve an immediate problem, right? But solving an immediate problem can bring you more problems later on when business goes back to normal, and you find that you have gotten rid of the people that you need the most, right? So I think it is important at this point of time for companies to evaluate the type of people they want to get rid of, right? The type of skills they will lose if they get rid of these people, and how fast are they going to be able to recover those skills. Now, one interesting thing that I read on the 18th of April, MEF came out and said that they expect to see 500,000 layoffs and retrenchment, right? And that's what MEF said on the 18th. And then they said that on top of this 500,000, there are 500,000 new entrants coming into the job market, which means graduates, people who are graduating from local as well as overseas universities, right? And they put 500,000 as the number, which means that we have got 1 million people out there who are going to be without job. As at March this year, there have already been 15,000 retrenched people who have been retrenched. Those are the statistics that I have read on, So whatever it is, nobody likes the word retrenchment, but I guess it's something that we cannot avoid. It's something that a lot of companies will be doing and will have to do in order to stay afloat. Sometimes it is better to chop off one arm so that you can survive, rather than
I suppose so. Yeah.
Yeah. Right. So,
Well,
I guess this is the situation right now. Yes, I have been involved in retrenchment exercises before in 1998 when I was with a hard disk drive company in Prague. We closed the company and we retrenched 4,500 people, right? And that was very painful because putting 4,500 people out in the market is no easy task. So today, MEF is saying that 500,000 people are going to lose their jobs, and probably that is being too optimistic because I'm not sure what's the number.
Yeah, but I can sense even from your tone of your voice and your body language, Bobby, this is a topic which is a very challenging area to talk about human resources. awkward and difficult one, you know, and I totally can feel you. Okay, to be fair, ladies and gentlemen, these are the kind of topics that we've raised so far, which can be a one webinar by itself. In fact, we can have 1 hour discussing only about salary, 1 hour talking purely about leave or unpaid leave. I'm sure Bobby and Rachel will agree. And we can even spend 1-2 hours talking about retrenchment, because so many layers. And don't forget, we haven't talked about retrenchment of trade union workers, right? But we haven't even gone there yet. Yeah. So employment, as you know, some people study employment for years to be expert, and so we're trying to do it in 1 hour. So bear with us. Our speakers are doing their best. We've got 25 brilliant questions so far. Some of them have been inadvertently answered by the panelists, but I'm going to do 2 in 1 now, Rachel and Bobby, pertaining to the government subsidy and the question. So we kill 2 birds in 1 stone. I have a few questions here. Let me read out generally, then we go straight to the subsidy. And so while Bobby explains the subsidy, maybe Bobby and Rachel can straight away answer the question, right? There is a query here from the panelists. Thank you so much for your questions. The time now is 4:50, so we are going towards the end of our part. One question said that, let's say employer has applied for the subsidy program, can the employer still proceed to pay cut or retrench the staff who earn more than 4,000? So that's one scenario. In short, the company applied, got a subsidy, can they retrench the worker? That's one. Then if an employee consent to a 50% pay cut and yet the employer had applied for the government subsidy, which is in contrast to the government subsidy conditions, is there any consequence for this? So this is what you say, Bobby, it's meant to retain employee, but some of the company very champion, they tell the employee, you take 50% lah. Then behind the scene, the company go and apply for the subsidy, get the money. So is there any consequence for that? Then another one more is, hang on. Yeah, these are the 2 specific questions on the government subsidy. So Bobby, I would like to invite you to maybe give a general, you're going to be our teacher today, you're going to teach us about the subsidy program. A quick view before we start our discussion, and then zoom into all the Q&A. All yours, Bobby.
Okay. As we have said, there are three subsidy programs which has come up. One is the System Insurance Pekerjaan, all right, which is actually, the EIS, unemployment insurance, actually came into force in 2017. And this says that if the person is unemployed or made or retrenched or made redundant, whatever, then the person can apply for this subsidy, which ranges from probably 80% to there's a scale down model that you get 80% for the first month, and then it goes down to 50%, it goes down to 40%, up to 30% for the next 6 months. So the payment is paid directly to the employee. It doesn't impact the employer because the employee has been laid off. The other one is the Employment Retention Program. Employment Retention Program, the government is trying to get employers not to retrench, but to retain these people. However, where employer cannot afford to pay, then what it says here is that in bahasa it says pekerja yang diberi cuti tanpa gaji oleh majikan, which means that you get unpaid leave by the employer. This is the second plan, which is the Employment Retention Program, right? This takes effect on the 1st of March 2020. And payment is made to the employer, right? The payment is made directly to the employer. The EIS is to the employee, the one is to the employer. And the cutoff is for people earning 4,000 and below. Okay, the employer will get 600 ringgits a month for 6 months. Okay, and then of course the third scheme is the wage subsidy, which came into force on the 27th of March. And then this is basically a subsidy that goes according to the size of the employer, meaning you have 75 employees and below, you get 1,002. Those between 76 employees to 200 employees get 800 ringgit, and the big companies of 201 people and above will get 600 a month. Again, those are the things that are currently in place. Of course, all these things are handled under SOCSO. So the detailed mechanism of how to apply for it and so on falls under the SOCSO website. Now, the next question that you asked was asked by one of the participants is that you apply, you get the money, and then you start to retrench your employee. Now the caveat here is that you cannot retrench them.
Yeah. In fact, I think Bobby, if I can add to that, if a company does that, and in the spirit of what Rachel was discussing just now, which I know you agree with me, that is mala fide, bad faith. You know, in fact, I think if the employee brings a case to court with that kind of evidence, it's a shoe-in victory for the employee. Company will be in big trouble after that. So I would strongly recommend to companies not to do that. If you're taking money from the subsidy, please do not retrench your workers.
No, another thing is there is actually there's something written there that if you because the company director has to declare what he has in the form, and if he makes a false declaration, right, he can be fined. The fine is quite hefty. Right? So employers need to be very careful. Not to mislead the government to get the subsidy. Number two, to ensure that the terms and conditions of approval must be strictly adhered to.
Makes sense. Yeah, I think that part of the announcement by the government makes sense.
Yeah.
Rachel, Bobby has of course, it's such a difficult, big document. He's managed to, squeeze everything into 3 minutes. Well done, Bobby. You do you have any comment about the subsidy so far? Have you helped any clients to apply for subsidy, etc., etc.? And at the same time, address the two questions. One of it was, I repeat, company cut 50% salary, still ask for subsidy. Two, the issue of retrenchment after taking the subsidy. All yours.
Thanks, Rick. I would say that all this what we've been doing ever since the announcement is that we are trying to tell our client what are the do's and don'ts regarding this ERP and WSP, wage subsidy program, because it's two different types of program. And one of the things that you need to know is both programs cannot run concurrently for the same employee. So if you're going to put an employee on unpaid leave, you cannot put them on wage subsidy. You cannot double dip basically. Because an employee who is on unpaid, you cannot say you're subsidizing his salary because there's no kaya, right?
Yeah.
So you cannot be taking the double dipping to the program itself. So you have to understand that you can apply for the same employee for 2 different months, all right? If once they come back to work and you need the assistant to pay their salary, then you can go under wage subsidy, right? And like what Bobby said earlier, there are 3 different groups that are involved. You have to first qualify in numbers of employee first. First thing you need to know for the purpose of wage subsidy, you have to qualify by numbers of employee. Then they look at eligibility. Eligibility is how many employees who is 4,000 and below. Let's say you have 100 employees. Generally, you have 100 employees, top-down management. But only 20 of them are 4,000 and below. So technically speaking, you only get 20 out of the 100. You don't get 100 times 1,002, or 800 ringgit or 600 ringgit, whichever category you fall into. You only get for that 20%. So you must know the difference. That's how it works. With regards to pay cut, you cannot do a few things while you're on the wage subsidy. Number one, you cannot retrench them, you cannot terminate them, you cannot cut their salary, you cannot put them on unpaid leave or forced leave. All this is not permissible up to 6 months from the day you apply.
Let's say
you apply in May, right? And once the thing started, you say, guys, I don't think we have any business going on. I think you guys should take leave. All right. If they apply leave, is different. But if you force them to go on leave, then that will be a breach.
Yeah, yeah, I agree. I agree. Long story short, once you get subsidy, you are bound by your contract. The government is saying to us, look, I give you money, don't sack. Right? Simple language, yeah? Yeah, you take money from the government, don't sack. That's a simple way. Okay, so is there anything else, Rachel and Bobby, you want to add on this matter before we start tackling the Q&A?
I just want to qualify now. When I say 4,000, remember, basically, in all these three plans, wages is as defined under Section 2 of the Employment Act, which means wages and all contractor allowances. Let's say a person earns 3,000 ringgit and he gets a transport allowance of 1,000 and so on, right? So all these things add up to, it is not the basic salary of 4,000, okay? It is salary, wages as defined in Section 2, which means all contractual allowances.
Interesting. Okay, thanks for clarifying the point. Thank you, Bobby. Rachel, can we? You want to try to? Shall we try the Q&A now?
Oh, yeah, sure.
Okay, yeah. Because to be fair, ladies and gentlemen, I think a lot of questions that you put up here, if you hear out Bobby and Rachel, they did answer the questions. And for the record, this conversation is recorded, and eventually it will be up on YouTube, probably in my law firm's YouTube, and I think Brickfields also will put up on the YouTube. So you can go there later and fast forward to the part you want to listen to the two speakers again. Actually, both of them gave some very good insight and ideas and legal input at every element of the conversation. Now, one question here, at 4:56 p.m., the question was asked, our company is an essential service. To comply to meet this requirement of 50% headcount at one time, can company and employees agree mutually for the employees to take a half-day unpaid leave? This is so that all workers get to work on rotation and shift basis. Is there a need to get employee to sign over an agreement for this? Can you both see the question? I repeat the question, Bobby. It is here. The question, the attendee is asking, our company is an essential service. To comply with METI's requirement of 50% headcount at any one time, can the company and employees agree mutually to take a half-day unpaid leave for the duration of the MCO? This is so that all workers get to work on rotation basis. So long story short, they want to get some of the workers to work in the morning, some workers to work in the afternoon. So then basically the workers are paid half. What are your comments about this? Bobby first.
Okay. Basically, I think companies must be aware that MITI says 50% of headcount. Let's say you have 1,000 people for the big MNCs. There were 1,000 people. You can only submit 50% of 1,000, which means 500 names. And when you submit, the 500 names are listed. Their names, their IC numbers, and so on are listed. Okay, which means that you cannot circumvent this thing by saying that, oh, out of the 500, I got another 500 who are staying at home. So we get this 500 that's approved to take half-day leave or to take leave. So the other 500 can come on board. In the first place, there's no such thing because the other 500 was never applied for. Right? So you cannot say that I want the other 500 to come and work so it is seen to be fair. There's no fairness in this because MITI is saying that you can only apply for 50% of headcount.
Yeah.
So you cannot say that I want the other 50 to afternoon shift or night shift. And then of course, I had one question that was asked, out of the 500 that I apply for, what if 10 of them don't show up? Can I replace the 10? The answer is no, because their names were never in the list in the first place. And if you are stopped by the police, you must show the list that you have approval to work.
Interesting, right? Interesting. Yeah. Rachel, you want to try or you want to move? I got a question for you to ask.
Yeah, go ahead.
Yeah.
Go ahead.
You see, Rachel, you mentioned earlier, I like the part that you mentioned about where some workers, they don't want to go, in fact, they don't want to work. They were asked to come back to work. They don't want to because of safety reasons, etc., etc. What are the rights of the employee and the employer in such a situation? One of them are asking somewhere inside here.
Okay. The thing is, when there is the issue of employee who doesn't want to work because of MCO, because they suddenly realized that balik kampung, now the company got the essential services license and his name is in the list, but he can't come back because he can't travel. So the right way is for him to apply annual leave. But if he refuses to, I have one that actually sends me a message saying the employee says this to the company. MCO, government says sit at home, so I'm not coming. That's it. He's not coming because it's MCO. The government asked me to sit at home. I'm not coming. So technically speaking, for those who are in essential services, employee cannot use that argument or that excuse to say you cannot come to work.
Yeah, you have to work. You have to work. Yeah.
So, all right. So for that case, those type of cases, I would cite the same rules apply for this any disciplinary action. Show cause, then you take whatever relevant employment disciplinary action up and including dismissal for misconduct or breach of employment terms.
But can I add this, Rachel, for the employee side, to be fair to the employee, even though the essential services, but let's say if the employer is recalcitrant or negligent in providing a safe working environment, for example, no social distancing, no sanitizing, nothing, the company don't do that. Don't you think that the employee can also argue that, look, I don't mind coming in, I know I'm essential services, but you are negligent. There's nothing in the company to save me. No hand wash, nothing, or blah, blah, blah. What do you say about that?
Then the employee can file a complaint to KSN or any relevant authorities that the company themselves is not providing such, because these are all requirements under the MECA for even the third phase for the employers to provide certain sanitization and certain measures for the employees before they can come to work. So if you think that your employer is not providing those basic necessity to ensure that the premise is clean, sanitized, and well prepared for you to work in, then you can actually file a complaint against them, which is naturally you can do so. And for those employer who are recalcitrant, like you said, right, they should know that any complaint, whether to the labor department authorities, right, would can amount to severe punitive damages, and also some cases like Section 99A of the Employment Act, the Labour Department can fine you up to 10,000 or imprisonment up to 2 years under the general penalties. So yeah, correct. So you have to be extra careful when you're dealing with employees because they have the right to file a complaint. It's not that, and you cannot say that the Labour Department won't listen to cases that is above 5,000. They will still inquire because they have the right to inquire.
Good point. At least you're showing balance. The employer can do that. The employee can request for this. Fair enough. I may be essential worker, but please keep it safe. Or else I don't want to go to office and die. You know? Yeah. Bobby, next question. We're coming to an end already soon. What about probationary? There's been many questions in the Q&A asking about probationary. So we've got a question here. Is it legal for employers to perform non-confirmation of probation due to financial circumstances? Then there's also an issue about a person who before joining the company, there's an MCO. So the in Chinese say cha to, before joining the MCO. Then what if the person joined the company but cannot physically go to office? How do you test the probationary, blah, blah, blah. What are your general comments about probationary during this period, Bobby?
Okay, on probationers, I think the test is that you don't confirm because of performance. There's basically there's no such thing as I got no money and I don't want to confirm you. Non-confirmation is dismissal anyway, right? So what companies need to do is to like MCO now, for the whole month you cannot assess the person's performance because he's away from work, he doesn't perform. Then you extend his probation, because the law is very simple. The law says that you will remain a probationer until you have been informed in writing that you are confirmed. So there's no such thing as automatic confirmation, right? So a person whose probation is for 6 months will continue to be on probation until such time as he has been informed in writing that he is confirmed. So the prerogative then is with the company that says, I cannot assess your performance. I will then have to extend your probation and assess you at a later date. You cannot get rid of people because cannot give the excuse that just because you're unable to come to work, I can't assess you and therefore I have got to let you go. Because probationers need to be treated the same way as confirmed employees, right? And as such,
the case laws on that point. Probationary and employees are same rights.
Same status kind of thing, right? Yeah.
What about you, Rachel? This issue of probation, have you been approached by any of your clients to deal with a very unique position where someone is either belum join the company but now joining during MCO, or during MCO is under probation? Any kind of general comments or observation?
Actually, both scenario happened to some of my clients. One that they have already made an offer and they have to rescind because there's a freeze of headcount. Because they are the moment MCO started, they were having financial difficulties. They have to rescind the offers they have made. So these people have not been on board, but were offered a position prior to that. They're supposed to start April, so they couldn't start because of the MCO, but client decided to rescind those offers. And those, I could say that if you were to choose to rescind the offer, then there will also be consequences. But the thing is, the employee who wants to bring you to court is not an employee, so their rights are in civil court. Now, in civil court, you have to also prove pecuniary losses. So what are the losses? What's your reliance on this? You haven't started work. You haven't contributed. What are your considerations? Again, there is no consideration in that sense. So when there isn't none, so technically speaking, the potential employee have risks of going to court to sue a company might be a bit difficult, I would say. Answers
interesting. I'm going to quickly go to some questions and I'll answer it because it's quite straightforward. We have an inquiry said, do we need to still pay our foreign workers who are daily rated if their names are not on the METI? My answer is, if you are under a contract to pay, you have to pay. That's because contract. This is exactly what Bobby talks about, the earlier one. METI said 50%, but you're under contract to pay the other 50% anyway. So the company is still obliged to pay. Financial, you see, ladies and gentlemen, we are talking about rights. Rights and cash flow are two different issues. So the two panel speakers are talking about rights, the law, and the principles. If you notice throughout the interview, the question we pose is about what principles do you apply. But cash flow is a separate issue. If you have no cash flow, it may be beyond issues of contract, it may be beyond issues of law, it's all down to negotiation. So even this other question, there was one about, that one person asked that maybe you have no right to, hang on for a while, of all the times there's someone who came to my house to collect an item. Hang on, can you sort it out, please? Sorry, my poor wife is now running over to. Sorry, dear. See her running, Okay. Someone asked about can the people who are, hang on, I was talking about foreign workers, and then there's one question here. Sorry, ladies and gentlemen, sorry, my mind got a bit kacau just now. We have made a few, there's one question here, we have made a few employment offers which was accepted prior to MCO. We now cannot practically take the employees on. How do we cancel the offer? What are the consequences? So technically, they have already accepted the offer. Rachel already answered that. They have already accepted before the MCO. There is a contract. Maybe the only thing left we can negotiate is maybe when it starts. So if you want to cancel the contract, of course, the consequences is that the company may get sued by the person. Of course, damages will be low because there's hardly any loss, but yeah. Also one here, someone said this, that during MCO, you can't retrench. No. None of the panel speakers said that. No one said that you cannot retrench now. See, some companies already started the retrenchment process long ago. And ngam ho, the retrenchment is going to take place now. So technically speaking, the company can still do that because they have already started the work many months ago. But if you start your retrenchment now, and the reason is MCO now, that one cannot. That is what Bobby and Rachel say, right?
Let me clarify that. It's not that you cannot do it during MCO. You can, but you cannot use MCO as the
As a
reason.
reason, yeah, spot
That's
on,
what
yeah.
the retrenchment must still be premised on business loss, restructuring, or any other reason that is based on case law, but not on MCO, because there's no law saying that MCO therefore equals retrenchment.
Yeah. So then, good point, Rachel. And then one question for Rachel is a general one. I think you already mentioned earlier. Say, can I renegotiate those on contracts, reduce their wages because work from home has reduced? Basically, the issue of negotiation. I think the answer is yes. But maybe Rachel, you want to give a few more general ideas on how you negotiate before I go to Bobby.
Well, I think the key point to every is the right messenger, sending the right message and the right messenger to talk about this. Normally, we'll send a HR person lah. So whether you like it or not, the HR person is always the right messenger. But the message that you have to deliver is making them understand. Like what Bobby said, transparency is very important. I think we lack that because we believe that issues relating to monetary in the company has nothing to do with the employee. They don't need to know. They just need to know that they receive salary every month and we are paying their salary, then that's okay. But that's not okay, because that's a sign where you have very little engagement with your employee. And when you need them to jump on the bandwagon with you, to understand and to cooperate, you will not get them to do so because you have never engaged them in the first place. So that is where you will find yourself having difficulty communicating because you have never communicated with them to begin with.
Yeah, agreed. Yeah, it's all about the communication skills, a lot of it. Bobby, last question for you. Generally here, you can see a lot of people are asking about the, can we defer the payment? What are the rights to defer? And then there's also a question about, hang on here, I took so many questions. Thank you very much. The 38 questions. Then one more from Satish. Following Rachel's example, if an employer unilaterally refused to pay or reduce the salary and the employee makes complaint to Labour Department, what can the Labour Department do to the employer? So, yeah, sorry?
Section 99A, 10,000 if they want to.
Okay. So Rachel has answered, even though it's lagging. But Bobby, generally across your comments pertaining to issues of deferment, issues of salaries, retrenchment, what are your general comments on the legality, the validity, and the viability of doing it? Legality, validity, and viability of doing it. All yours.
No, basically, in terms of changing salaries or benefits, I think, like we said, let's take a look at the three categories that we talk about. For people under the Employment Act, just strictly follow the Employment Act. We can't change the terms and conditions and benefits. Those people who are out of the scope of the Employment Act, I think everything is negotiable. I think if the employers are transparent and have gained the trust of the employees, people at this juncture would rather keep their job than to lose their job. So if you have an executive, an engineer, a manager, you can negotiate anything with them because A, they are out of the scope of the Employment Act. And now is the time to negotiate because rather than they losing their job or their colleagues losing their jobs, it is better that we keep everybody in the family, kind of thing, right? So of course, the third category of the unions, you can't, I mean, again, in every collective agreement, there is an article that says that during the pendency of the agreement of the CA, neither party shall vary the terms and conditions. So there's nothing you can do, right? Of course, it doesn't mean that you cannot negotiate with the unions, but it is going to be a harder task.
Okay. So you nicely summarized the situation we are in. Ladies and gentlemen, it's already 5:20. We're coming to the end of our webinar. Some take-home points so far, if I can summarize the last 1 hour, 20 minutes. The law pertaining to wages paid is under Section 2 of the Employment Act. We've heard the panel speakers discussing about the legality of deferment, suspension of salary. Basically, the Employment Act is silent on this. But we understand the situation is unprecedented. So Rachel has offered some practical ideas on how to make payment, even including payment in kind, or alternative payment. And of course, Bobby gently reminded us that the Employment Act is silent on this. So there's a balance to be paid. And also, I like how both Rachel and Bobby, particularly Rachel, gave some ideas on if you're going to do something, do it in good faith. And if you are brought to court as a company, then at least the company can show that you tried. For the employees, your rights are protected. Both speakers very clearly said that to retrench is not easy. You can't use the MCO to retrench a worker. Once the employer takes the subsidy from the government, the workers and the employees' rights are protected. You cannot be retrenched, you cannot be sacked. So there are a lot of safeguards in place for the employees. That is a take home from the two panel speakers so far. With regards to the subsidy application, Bobby has already clearly explained how it works, the cutoff point, the trigger point, the process, and I repeat, the protective mechanism. Once you, as we conclude, once you take money, you can't sack. That is the long story short, simple principle. And then, of course, there are many small peculiar issues on probation, yes or no, foreign worker, yes or no. Those are all case-to-case basis. At this point, I would like to say, if you have any inquiry, you can always look for Bobby Gay. He can be found on LinkedIn. Look for him. You can send him a private message. And Rachel, she's an active speaker for MECA. Look for MECA, MECA, on Facebook. I think it's called MECA Consultancy Agency for Employment. You can find there, send a DM, can ask them. They are all prepared to answer your question. With that in mind, can I now invite everyone here? There's about 166 left. At the peak of the talk, we had 190 old people. Thank you very much for signing on, but can we give a round of applause to our panel speakers? They spent 1 hour plus with us. Rachel having a fight with her internet, trying to hold on to the internet so that she can say. I know some of you have raised your hands. I believe you want to say something, but I apologize. We are unable to add you on as a speaker because there's not enough time. But thank you very much for your support. I'll end by saying this, ladies and gentlemen, for this employment matter. Number one, I have to confess, there is no one answer which will fit all. We just can't find it. So the only way we can do is you take case-to-case basis. Number two, all the human resource practitioners, if you need help, go out and look for help. There are lawyers, there are people like Bobby, there are people like Rachel who are able to help you. And thirdly, the government subsidy has already put into a defense mechanism, protective mechanism for people. So things are done in order to retain and maintain employment. But my message to all the employees, while we know the employers are in trouble, many of them are in trouble, but for the employees, hang in there. Try to work with your employer, work it out. I know some employers are difficult and they may not have been transparent with you before, but there are many employers out there who are really struggling. Work out a deal with them. There's always a way out. Try to retain your work. And you know, I don't think going to litigation is going to solve everything. Rachel, it's not going to be a nice thing. Oh, I take it to court. I go to court. I go to court. It's not necessarily a good solution, right? Try. And I'll end by saying this, ladies and gentlemen. I think Rachel knows how I'm going to end this. You know, it's a difficult time for all of us. We live in really weird times where we are all meeting 160 people on the internet like this. I am wearing a jacket in my house. I never wear a jacket in my house before, you know. So it's you know, very weird time to live. But yet, this time makes us all think. We are all made to think, to find a way out. And I think thinking is very important at this point. But what I want to say is that all of us, we have to do this together. We have to come together. Because if we continue fighting with each other, nothing is going to be solved. Because to me, the only way we can prevail is together. So together, we will prevail. So with that in mind, I would like to thank Brickfields College for having Bobby, Rachel, and I. I'd like to thank people like Mr. Rajasingham, Mr. Rajan, Ms. Julie for the support, the IT and the technological team behind Brickfields College for running this, giving us a platform for doing this. To the 190 people who participated, thank you very much. I hope you like it. let Brickfields know if you enjoy it. We can do this webinar again. Until such time where we can reach out to as many people as possible. Bobby, any last words? Rachel, any last words? Bobby?
No, thank you so much. Thanks the participants.
Thank you. Rachel?
Thank you, Brickfields College. Thank you, Rick, for having me again, and all the participants. Let me say this: in this such time, please don't only rely on the legality of matter. Apply rationality, and most important, apply empathy. You need empathy in times like this to get through the hardest part of this economy downturn. You cannot just apply, oh, this is my right as an employer, this is my right as an employee. Put empathy in what you do. Put yourself in someone else's shoe in order for you to be able to understand and for perhaps a little bit more giving in times like this.
Well said, Rachel. Very good. Together we will prevail. Okay. Bye, Bobby. Bye, Rachel. Goodbye, everybody. Thank you very much. Stay safe. Wash your hands. Bye-bye.